Her advanced age and her health issues, those were the reasons cited by the High Court for granting former First Lady, now Ilocos Norte Representative Imelda Marcos temporary freedom. While the Supreme Court used the Enrile Doctrine from 2015 as a precedent, critics say the ruling only proves double standards. Our debaters weigh in on this very issue. Hello, I'm Mikey Oreta and you're watching Square Off, Season 16, The Firm Debates. So will she or won't she face jail time, that is? Last month, former First Lady Imelda Marcos was found guilty of 7 counts of graft by the Sandigan Bayan. Some say her arrest will be a rare conviction among many corruption cases and that she will likely appeal to avoid prison or lose her congressional seat. The 89-year-old Iron Lady sentenced to serve 6 to 11 years in prison for each count of violation of the anti-corruption law that stems from the alleged $200 million she illegally funneled into Swiss foundations in the 1970s. The conviction is hailed by some as justice at last. But there's a twist. The court allowed her to post a 300,000 peso bail and to appeal her sentence, citing humanitarian reasons, like her advanced age in particular. The same grounds used by the Supreme Court in the case of former Senator Juan Ponce Enrile, who also happens to be running for office again next year.
Si Imelda, convicted na, nakalaya pa, binigyan pa ng piyansa. Nasaan ang justisya dito?
Lalabas ni minsan ay hindi makakatikim ng kulungan ang dating unang ginang sa kabila ng lahat ng nangyari, sa kabila ng lahat ng nanakaw.
Pag mapalaya si Imelda Marcos dito, hindi yan ang mensaheng darating. Ang mensahe, pwede ka palang mangurakot, basta mangurakot ka lang ng malaki at hindi ka makukulong.
But not all were against the move. So after all is said and done, should Mrs. Imelda Marcos be allowed to post bail for humanitarian reasons? Arguing for the affirmative side is Beda University. Committed to the battle for the greater good, the Red Lions of Beda University.
I would say that my teammates share the passion as I do. We are very much passionate with knowing and fighting for what is right. We've always been at the core of what Beda Law Circle has to offer. We have a very good research team, and we believe that it is very much important for a debate to be grounded on very good research in order for us to have well-rounded results.
My teammates are very focused. They're very they're very good public speakers, and I am very confident that we can win the ANC Square Off as long as we're cooperating side by side each other.
Although this is my first time teaming up with them in this craft, I believe they are equipped with the relevant capacity to debate. And although all of us haven't really engaged ourselves with this type of craft, I believe we have the capacity to learn and train ourselves well.
Team Beda University. Wise, humble, committed. And taking on the negative side is Arellano University. From the institution guided by truth and respect for academic freedom, the new breed of lawyers from Arellano University.
Our team strategy is to tell the truth and to show the facts and to ensure that the judges understand where we are coming from.
When it comes to debating, there aren't any two people I would trust more, I would say so. They're very good people to work with. Their skills and their personalities, I'm very comfortable with the both of them. When it comes to winning the match, we would like to provide context, or rather a bird's eye view of the situation.
These guys are hardworking, and without them, we won't be here. Our team strategy is to stick with the law, stick with the facts, stick with our best understanding of how to best resolve the problem in the motion.
Team Arellano University. Benevolent, passionate, honest. Let's now meet our distinguished judges. First off, we have attorney Christine Charis Xiao, a junior partner at the VNA law firm. Next, we have attorney Axel Rupert Cruz. He's a professor at the Ateneo de Manila University. And presiding as our chief adjudicator is Judge Mervin Jovito Samadan of the Regional Trial Court Branch 40 of Dagupan City. We're using a modified Oregon Oxford format. The debate is between two sides, the affirmative and the negative, with 3 members each. Each debater from the affirmative side argues the necessity, beneficiality, and practicability of the proposition, while the counterpart debaters on the negative side oppose these arguments. Each debater is given 4 minutes to deliver a constructive speech and rebut the previous argument. Each debater is given 2 minutes to interpolate or cross-examine the opposing debater. Only categorical questions may be asked. Each of the judges may ask 1 question of each speaker within that speaker's time limit. The judges score each team in terms of manner, matter, and interpolation. The team with a higher score from each judge gets a point. The team with the most number of points wins the debate. The chief adjudicator rules in the event of ties, objections, or contestations. This week's proposition: let it be resolved that Mrs. Imelda Marcos should be allowed bail for humanitarian reasons pending appeal of her conviction. First up, for the affirmative side, we have Red. Red, you've got 4 minutes to tell us why the former First Lady should be allowed to post bail because of her advanced age.
The Constitution is not a merciless persecutory arm. It prosecutes, but it never persecutes. At its core, this debate is about the striking of a balance between the state's prosecutorial interest and the right of the accused to provisional liberty. After all, an accused is deemed innocent until final conviction. In dubio pro reo, when in doubt, rule for the accused. Post-conviction in the RTC, the court in its discretion may consider humanitarian grounds in the grant of bail, which is defined to include one's age, health, social and political status, among others, and it is considered in the furtherance of the state's interest to secure court appearance. Beda University is proud to defend that humanitarian considerations attendant to Mrs. Marcos's case should be afforded the greatest weight because it is more in line with the purpose of bail to secure appearance in court and the human rights of the individual. We have 2 points to argue, Your Honors. First, humanitarian considerations are within the precepts of the discretionary power of the courts to grant bail. And second, Mrs. Imelda Marcos's advanced age, frail health, and past records are humanitarian considerations which necessitates the grant of bail. As to the first argument, in this stage, the grant of bail is already discretionary. Humanitarian grounds may be used as a guideline because being an accused does not mean persecution and being stripped of human rights. These grounds are in fact not new inventions giving special treatment to Mrs. Marcos, but are present in a long line of cases dating back from 1946 in the Telerama versus People's Court case, where it was said that independently of the merits of the case, the illness of the prisoner is a circumstance which the humanity of the law considers regardless of the charge and the stage of the proceeding. This was continuously used in the cases of U.S. versus Perganan, Rodriguez versus RTC, and Enrile versus Sandigan Bayan, among others. In the Enrile case, it was stated that the granting of provisional liberty will enable the accused to tend to his medical condition, and this will not only aid in his defense, but will guarantee court appearance. And if these considerations exist, bail must tilt in favor of the accused, and any kind of detention neither would be helpful, because even so, she would still be detained. And preventive detention is only to secure attendance, which bail can achieve in our case. Now, as to my second argument, Mrs. Imelda Marcos have compelling humanitarian considerations which necessitates the grant of bail. Let us look into the facts of the case. First, Mrs. Imelda Marcos is already 89 and was only sentenced 6 to 11 years imprisonment. Second, according to Dr. Quanang, she has diabetes, cardiovascular disease, static mini-strokes, UTI, and colon polyps. These diseases require stress-free environments, which, when disregarded, would refrain her from being duly present in court. As said in the Dalarama case, illness, among others, regardless of the merits of the case, is considered in granting bail. Mrs. Marcos even have faced many charges in the past, but never has she been in hiding. Even in the recent graft case, when she was on bail, she was very much free and had every chance to leave the country, but she did not. She remained, so it may not be said that she is a flight risk. At this instance, the consideration in granting bail is not only whether the state interest for court appearance is present, but it strikes a balance to not erode the pillars of constitutional rights. To end this, I quote Justice Martinez, "Equity regards the spirit and not the letter, intent and not the form, the substance rather than the circumstance, as it is variously expressed by different courts." Thank you.
2 minutes for the cross-examination.
Mr. Speaker, is there a legal definition for humanitarian consideration?
Yes, it has been defined in the case of Dalarama versus People's Court.
Is it found in the ponente?
Yes, it was
no,
said there.
it's
that
found
regardless
in
of
the
merits
separate
of the
and
accused,
concurring
the
opinion
illness,
of
no,
Justice
it's not.
Rion.
It is,
Next, you've
no,
read
it's
Dalarama
not.
case.
It is in the case
You've
of
read
Dalarama and a
Dalarama
lot
case.
of other cases
You've read
after that.
Dalarama case. Have you
Of course
not?
I did.
In that case, was the person under hospital arrest? Was
No.
he not? Was he not instituted in the Quezon Institute because he had a sickness?
No.
He had an illness.
Well, you could see
I
there.
assume,
Yes,
I
of
assume
course.
you've read the
You could
case.
see there
and accept,
that regardless,
but you're not,
it was ruled that
you're
regardless
showing
of
your
the
ignorance
merits
of the case of Dalarama,
the illness of the
where
accused
that
is a
person
consideration
was actually
which the humanity of
in
the
the
law
Quezon
takes
Institute and was
into
not
consideration
allowed
in granting bail, regardless
in the case
of the stages
Dalarama, he
of
was
the
not
proceeding.
allowed bail. He was
So what's your
continuing
point,
to be
counsel?
instituted. I'm saying my point is that there are instances where a person who is sick, who has medical infirmities, can be confined in hospital arrest.
But that's not the purpose of bail, because bail balances both the
In this
professional
case,
liberty
is
of
bail a right or a discretion of the court?
It is discretionary.
Under Leviste, does it say that bail should be granted to the accused simply because none of the circumstances under Rule 114 are present?
If you have seen the bail order, Leviste was actually quoted there. It was
Leviste was
that
quoted
Leviste,
in there in saying that the bail
Yeah.
should not be granted with laxity and only
Yeah,
should
it's
be
just
granted
because of
for
strong
grave
caution,
reasons.
and in which, in this case, we could actually see that
Was
there's a
there
bail
caution
hearing
in
for
this particular case?
Of course.
Did they
We have
exercise caution?
Yes, actually, in fact,
All
I have
right.
here a copy of
All
the
right.
bail order.
All right. All
where
right.
Everything,
Okay.
all
Given the
circumstances
fact
were
that you
mentioned
say
in the
that there's
case.
caution in this case, how much was the bail?
300,000.
In the case of Enrile, how much was the bail?
Tell me.
1 million.
And so?
So are you saying, lady?
Ross, you now have 4 minutes to advance your argument on why Mrs. Marcos should not be allowed to post bail.
Your Honors, Chief Justice Bersamin, the same ponente in Enrile versus Sandigan Bayan, said in Magsino versus De Ocampo that the bare invocation of interest of substantial justice is not a magic wand which will automatically compel the court to suspend procedural rules. Procedural rules are not belittled or dismissed because they result in a prejudice to substantive rights. They are required to be followed except only in the most persuasive reasons to relieve a litigant of injustice, commensurate to the degree of thoughtlessness in not complying. Therefore, favor of the court is won and lost on our obedience to lawful orders and truthfulness in the face of inquiry. On both counts, we say that Imelda Marcos has lost. We ask, was she entitled to bail at all, given her unjustified absence during the promulgation? We answer in the negative. We look at the rules which govern this particular case on notice and promulgation. The internal rules of the Sandigan Bayan have a duty, impose a duty on counsel and accused to furnish their contact details, cell phone, landline, and email. The Sandigan Bayan will call and text and email all notices to counsel, accused, and your witnesses. This means, ladies and gentlemen, that all means are secured in order to give notice to counsel and the accused. Under the revised rules on continuous trial for criminal cases, the date of promulgation is even announced in open court. Therefore, there's absolutely no reason for accused and counsel to be ignorant of the date of promulgation. We take a look at Rule 120 of the Rules of Court, where absence without justifiable reason forfeits all post-conviction remedies, including bail. Let's take a look at Imelda Marcos's reasons for not attending the promulgation. She says she has multiple organ infirmities which are under strict rules from her physician to refrain from stressful conditions. Number one, the medical certificate was not notarized. It's a mere scrap of paper made by a non-government physician. In Tarapan versus People, only government physicians by the virtue of their oath of office as civil service officials are competent to examine persons and issue medical certificates. Under Section 44, Rule 130, these medical certificates are prima facie evidence, and as held by the Supreme Court, an unverified medical certificate not issued by a government physician is considered unreliable. Unlike the case of Enrile, who was examined by the PGH director, Dr. Gonzalez, and another cardiologist who both testified to his risk of life-threatening events. Number two, she is under strict orders to refrain from stressful conditions, but this is belied. Yes, sir.
Mr. Speaker, are you saying that the Sandigan Bayan took judicial notice of the medical certificate issued by the doctor on behalf of Imelda Marcos?
Your Honor, there is nothing in the Sandigan Bayan issuance that says that the doctor who issued the medical certificate actually testified under oath as to the conditions of Ms. Marcos. Now, number two, she's the incumbent representative of Ilocos Norte. She attends sessions and hearings and meets her constituents all the way up the north. She planned to run as governor of Ilocos Norte, stepping down only after conviction. And she attended numerous social functions from TV and movie companies and even attended Amy Marcos's party on the night of her convictions. These are inherently stressful events in her life, and yet she did not step down, and yet she only stepped down from running after this conviction. Finally, the most damning admission is that she lied on her motion for post-conviction remedies, admitting in open court that the reason she was unable to attend is she did not know. God, she did not know. Therefore, despite everything which the Sandigan Bayan does, in order to give notice to the accused and counsel, she did not attend. And therefore, ladies and gentlemen, we must remember the first Latin maxim we learn in nursing law. Ignorance of the law excuses no one.
2 minutes for the cross-examination.
Good evening, Ross.
Good evening.
So, Ross, is a notice necessary to be given the accused before the promulgation of judgment?
It's a function of
Of course it is. So, have you read the bail order released last November 28, wherein it was said by the Sandigan Bayan that it's actually the absence is actually justified?
The court can retry the facts,
So
and this
her
is why we're
absence
having
is
this debate.
justified, and she may make use of post-conviction
We're trying
remedies,
to
Ross.
review the facts
Now,
of this case,
let's
which
continue.
is
Remind
necessary
me.
in order for us to do this.
This is my time, counsel. Remind me. Was there a recent graft case against Mrs. Marcos?
There are several graft cases under Ms.
Was
Marcos.
she in the public eye during these times?
Yes.
So, Mrs. Marcos was never in hiding, and therefore she is not a flight risk,
Therefore,
correct?
she wasn't under stressful
let's continue.
conditions.
Has the court ever granted discretionary bail factoring
Therefore,
in
she was ready
humanitarian
and able in
consideration?
order to attend the promulgation.
Please answer my question, counsel. Has the court ever granted discretionary bail factoring in humanitarian considerations?
Age and health, not humanitarian consideration.
These are humanitarian conditions, counsel.
You're making
Perhaps
your own
you didn't really
definitions.
read De La Rama. Counsel, have you read the 1946 case of De La Rama?
Yes.
It was said here that the illness is actually a circumstance that the humanity of the law considers.
That person had
so
tuberculosis,
the use of
which is why he
humanitarian
was confined.
considerations is not a new concept and has always been a consideration, correct?
He had tuberculosis.
Now, counsel,
Imelda Marcos does
post-conviction in
not.
the RTC, bail may be granted as a matter of discretion, correct?
That discretion should be exercised with
Yes,
great
okay.
caution.
So is there anything
Something
in the
which we are
Constitution
contending
that
in
sets
this
a
debate.
standard on how this discretion may be exercised? Is there anything in the Constitution?
Complete your point.
Is there anything in the
Complete
Constitution?
your
There is
point.
none, counsel.
Complete your
so
point.
given the absence, the
Complete
courts may
your point.
exercise their discretion to its full extent so long as it is not prohibited by the law. So
The
they may make,
discretion of the
so they may
Sandigan
make
Bayan
use of these
can be
humanitarian
reviewed, which is
considerations
why
in
we're
the
having this
exercise
debate.
of that discretion.
Let's now hear from the second affirmative speaker, Joel. You've got 4 minutes to tell us why it would be beneficial to allow Mrs. Marcos to post bail for humanitarian reasons.
If we can achieve the purpose of preventive detention with the posting of bail, we see no further benefit in placing behind bars an accused which is innocent in the eyes of the law. Your Honors, if there are humanitarian considerations that are present and there are no bail-negating circumstances, the scales of justice must tilt in favor of the accused. First, rebuttal. I would like to point out that the negative side did not respond to the spirit of the motion. We are attacking the humanitarian considerations as a basis for bail. Your Honors, Affirmative's first speaker already proved that the humanitarian considerations are compelling and strong factors in tilting the scales of the court towards the granting of bail, which the negative speaker miserably failed to disprove. He would go to the extent of belittling medical certification, which is a valid evidence in the court of law. Your Honors, we have 2 points for beneficiality. First, we are able to achieve the twofold purpose of bail without preventive detention. The general rule is to detain the accused upon conviction, and by its nature, the only purpose of preventive detention is to secure court attendance. While it guarantees custody, it disregards his right to liberty. Your Honors, as discussed in Enrile versus Sandigan Bayan, bail has a twofold purpose. First, securing court attendance, and second, which is the most important one, is to give provisional liberty to the accused because it is rooted in the right to be presumed innocent. The better goal is to strike between a balance between the two purposes and the enforcement of the rule of law. Why is it important that the two purposes are achieved? The Constitution protects all the interests of its stakeholders and not just of its own. Yes, the ultimate interest of the state is to secure Imelda Marcos' appearance throughout the whole criminal prosecution, and she should be held accountable if proven guilty. The accused should still be afforded the right to liberty pending appeal. And now it begs the question, how does bail secure the attendance of the accused in court? By imposing strict bail conditions in accordance with the rules of court. We can increase... Yes, ma'am.
Are you saying that she is entitled to bail because she is not a flight risk or because of humanitarian reasons?
Both. There are no bail-negating circumstances in this case because she is not a flight risk as discussed by my first speaker, and there are strong and compelling reasons that to consider human considerations such as her age and sickness. And now how do we secure the attendance of the accused in court? By imposing strict bail conditions. By all means, yes, Your Honor.
Madam Speaker, is Imelda Marcos suffering from a debilitating disease that a hospital arrest or a detention facility cannot attend to?
We consider that argument, Your Honor. However, even a hospital or house arrest is still restricting the liberty of the accused. It means that the right to liberty of the accused is still impaired. Whereas if bail is granted, then her rights as an accused granted by the Constitution is secured. So we can increase the bail by all means, and we could restrict her mobility within the country. If bail can secure the purpose of preventive detention, then there is no reason to detain her anymore. The only way to enforce equilibrium between the two is to secure court appearance and liberty. The only remedy is granting bail, which brings me to my second argument that if we deny bail, the court will augment legal injury that will be suffered by the accused. Pending appeal before final judgment, an accused is entitled to the right to be presumed innocent and right to liberty. Imelda Marcos is entitled, despite the controversy surrounding the... Thank you.
2 minutes for the cross-examination.
Good evening, Counsel. Are you aware of the case of Rufina Chua versus Court of Appeals? No, you are not aware, Eshu. Do you know that case, in fact...
You did not wait for my answer.
So, yes or no?
Yes.
That case, in fact, has more in common with Imelda Marcos as compared to all of the cases you cited, because in this case, someone was actually convicted for an offense
so
more
what is
than
your
6
question?
years. The thing
what is your
in
question?
This case, Ms. Speaker, I'm enlightening you as you asked. In this case, there was non-negating bail circumstances, but the court of appeal
thank you for conceding to us that there are no bail-negating circumstances
for granting bail, because according to the Supreme Court, the mere non-appearance in promulgation is actually indicative of flight risk. Second
please give your question.
Do you agree with the Supreme Court in their decision in reversing bail in this case? No, you do not agree with the Supreme Court?
What is the point of your
Do you
question?
agree with the Supreme Court? My point is, Ms. Speaker,
The Sandigan
in a case
Bayan
actually
did not
where
reverse.
someone was convicted, bail was denied even when there were no
Yes.
non-bail negating circumstances. Next question, are you aware of the case of Enrile versus Sandigan Bayan? Yes. Thus, you are aware in the main decision, the words humanitarian reasons does not appear even once
What is
in
your
relation
question?
to Enrile. Are you thus aware that, in fact, before granting bail on the consideration of age or health, they considered the political reputation of Enrile?
Oh, that
This
is
was
not true.
prefaced.
Humanitarian
It was a
consideration
precondition.
is not
Next question.
arbitrary.
Have you read
It will
the United
apply to
Nations
the other
Declaration of
octogenarians
Human
who are
Rights?
suffering from the same
Have you read
sickness
the
and
United
health
Declaration of
problems.
Human Rights? Yes or no? Yes. In the same case, in United Declaration of Human Rights, the granting
Counsel,
of
this
bail
is
or
only
human rights
this is also my
only
time to answer your
tempered. It's only
questions. You're not
tempered.
giving me the
Ms.
chance to
Speaker,
answer your
it's only
questions.
tempered by the rule of law. Ms. Speaker, you would agree with me that the principle of equity has no application when there are in fact strict rules. Yes or no? That
The
is
court
basic.
must rule in the
Yes, that
furtherance
is
of
actually
equity
true.
and justice
Next question,
at all
Ms. Speaker,
times.
are you aware of the bail as posted by Imelda in this case? In fact, you mentioned in your speech that there should be strict restrictions.
Okay, Alexine, you've got 4 minutes to tell us why it would not be in the country's best interest to allow the wife of the late dictator Ferdinand Marcos to post bail despite her advanced age.
Your Honors, good evening. We are one with the Sandigan Bayan in their vision of a graft-free country. Affirmative must prove not only that the accused can be granted bail, but that she should be granted bail on the basis of humanitarian reasons, that her case is of such an exceptional and unique character as to warrant the same when overwhelming jurisprudence has been against it. In our side, we argue that there is no legal nor factual basis thereof, and even if there was, or it is purely discretionary in this case, she should still not be granted bail because harms outweigh the benefits. First, it weakens the public's trust in our justice system, and second, it undermines our fight against graft and corruption. Your Honors, to the first point, from the offset we have established there is no constitutional right to bail in this case, as presumption of innocence terminates upon conviction by trial courts, as held in the case of LIBRT versus CA. In the same case, the Supreme Court stated that the discretionary nature of bail does not mean its automatic grant. History dictates its restrictive approach, that it should be granted not with leniency but only with grave caution and only for the gravest of reasons. In arguing for the exception rather than the general rule, yes, Your Honor.
Would your position change if the amount of the bail was 1 million?
No, Ms. Speaker, because no, Your Honor, sorry. Because from the beginning, we have argued that there is in fact no legal or factual basis, that Imelda's act of impunity actually prevents her from availing already of post-conviction remedies. And to grant bail on the basis of humanitarian reasons only adds insult to injury. To establish or to apply humanitarians in this case means to apply it to all of those who are equally of the same class, the old and the infirm. But that has not been the case, as Bureau of Correction statistics would show 3,500 aged detainees currently languishing in jail, including those pending appeal. Your Honors, with all due respect, we find no substantial distinction between Ms. Imelda Marcos and those situated and like accused before her as to justify the granting of bail for her and the denial of bail for others. In fact, People versus Fitzgerald, the Supreme Court stated that bail is not merely a sick pass for an aged or ailing accused needing medical care. Ms. Imelda Marcos, in effect, Affirmative would have you give accused special treatment and run the risk of unfounded judicial exceptionalism, in the words of Justice Leonen, when in fact humanitarian consideration can still be applied in our case, in the case of hospital arrest. There has been previous cases for that in the case of Gloria Macapagal Arroyo. For example, the appearance of bias or prejudice can be as damaging to public confidence in the administration of justice as in the same as actual bias or prejudice, as held in Montemayor versus Bermejo. Second point, it in fact undermines our fight against graft and corruption. Consider in 2012, 79-year-old Ricardo Castro was charged for stealing 36 pesos worth of chocolates. In this case, People versus Imelda, she was actually convicted of 7 counts involving $200 million in anomalous transactions. In the former, justice was swift. In this case, the warrant of arrest was deferred. Rather than cowing any potential wrongdoers, you actually give them hope that as long as they can live long enough, they can use this as a ground for bail, which actually has a real possibility of happening, Your Honors. considering the long and arduous trial proceedings involved in graft and corruption cases. People versus Imelda Marcos was filed in 1991. It took 27 years to finally get a conviction. You send a dangerous message that those with power, influence, and money can protract litigation for long enough for them to avail of post or provisional liberty remedies, which is ironic considering that the proceeds of the fund of the crime they were convicted for would actually allow them to post bail to avoid time for committing the same. We must not and cannot engender in the public the knowledge or the idea that there are two sets of justice, one for the rich and powerful elite and another for the rest of us. We are fighting for a higher ideal, a rule of law and not of men. Thank you.
2 minutes for the cross-examination.
Counsel, you still did not engage in the spirit of the motion. First question. The 6 graft cases were filed against Imelda in 1991, 27 years ago, correct?
7 grounds.
Is she still living here in the Philippines?
Yes.
Yes. And in those times, did she even attempt to leave the country?
Actually, yes. She went abroad multiple times.
Yeah, that was for vacation.
She has the means.
And these grounds are considered by the Sandigan Bayan in recent
means were
Relax, counsel. This is an intellectual discourse.
It is an intellectual discourse. I'm answering.
Don't shout. Okay, so I have a copy of the bail bond order here. That means that there is already a judicial determination that she is not a flight risk. So, second question, the right to liberty in Article 3, Section 1 is not absolute, correct?
No, it is not.
Yes, very good. And under the law, a valid conviction from a final judgment is a legal impairment of this right, correct?
Under the law,
yes. So in the case of Imelda, is there a final judgment already? Answer yes.
You are operating
counsel,
on the
why is it so hard for you to answer a simple yes or no question?
Because you're not making your point, counsel.
No, there is no final judgment yet. So we cannot already impair her rights. Counsel, would you agree with me that in the case of Imelda, bail is a matter of discretion? Your Honor, it is a matter of discretion. Relax, counsel. Calm down.
What's so special about this?
Okay, and there are certain restrictions in the courts of exercise of this discretion under Rule 114, Section 5, right?
You're contradicting yourself. You're saying it's discretion,
and
but that
any prohibition, the court must rule in the furtherance of equity and justice.
You're contradicting yourself, counsel.
Is there anything in the rules that say we cannot grant bail for humanitarian reasons?
Is there anything that says we should?
There is no prohibition. Therefore, the court must rule in the furtherance of equity and justice. Okay, counsel.
Are you saying the Supreme Court
is wrong? Please engage with us.
We are.
The purpose of preventive detention is to secure the appeal.
Let's now hear from the third affirmative speaker, Nicolai. You've got 4 minutes to tell us why it would be practicable to allow the Iron Lady of Ilocos, Mrs. Marcos, to post bail.
People versus De La Rama, US versus Purganan, Enrile versus Sandigan Bayan, Rodriguez versus RTC of Manila, all of which are cases in which humanitarian considerations have been used in the court's discretion in granting bail. Your Honors, we are not going against Mrs. Marcos. We are not giving her special treatment. We are merely continuing a long line of jurisprudential history. Since judgment is not yet final, Mrs. Marcos is to be presumed innocent and like any other innocent person must be accorded respect.
Is there jurisprudence denying bail on the basis of humanitarian reasons?
So far, Your Honor, there has been no case which categorically denied it. But we do contend that it is still within the discretion of the court. Our case is about humanitarian considerations being factored into the court's discretion in granting bail. I have one crucial argument in this speech which relates to the interest of the accused vis-a-vis the interest of the state. To criticize the law is different from to criticize the person to whom the law is applied. Before that, a bit of rebuttals. They contend that the courts do not have the source of this power, to which we say that courts traditionally have the power to decide on cases of human rights, which includes the presumption of innocence and the right to bail. Secondly, they argue on the promulgation in absentia. Last November 28, Imelda Marcos was already given bail. The Sandigan Bayan already decided that her justifications were correct. Thirdly, they already judged Imelda Marcos to be guilty of graft and corruption even before final judgment in the Supreme Court. The last time I checked, Your Honor, we live in a jurisdiction which abides by presumption of innocence and not the presumption of guilt. Team Negative is already presuming Imelda Marcos to be guilty of graft and corruption. Firstly, Negative bench argues in favor of preventive detention, whereas we argue the bail on humanitarian reasons must be granted. Let me clarify, Your Honors. Wherever we detain Mrs. Marcos, be it in a house, a hospital, a prison, all of which are forms of preventive detention, it entails a deprivation of liberty. In the absence of any reason to detain, she must be allowed bail. When we allow bail, we strike a balance between honoring the accused's fundamental rights
Mr.
and
Speaker,
securing her
what
appearance.
entitles the accused, in this case Imelda Marcos, to have a liberal application on the Universal Declaration of Human Rights?
Your Honor, as ruled in the case of Enrile versus Sandigan Bayan, as well as cases prior to Enrile versus Sandigan Bayan, by that case pronouncement, it's already deemed a part of the law of the land, Your Honor, and we believe that it can be applied in the case of Imelda Marcos, especially with all the circumstances my previous speakers already showed you. There are humanitarian considerations which must be factored into the court's discretion in granting bail to Imelda Marcos, and by virtue of the application of pro reo doctrine, we believe that the pro reo doctrine should tilt the scales of justice in favor of the accused. In our best case, Your Honor, her right to be presumed innocent is upheld, have her medical condition addressed, and guarantee her appearance. Additionally, the court would uphold the dignity of the person and our commitment to the Universal Declaration of Human Rights. Conversely, if we don't allow bail, despite the existence of humanitarian considerations, the humanity of the law becomes desensitized. It devalues a bundle of rights which comprises of the accused's right to presumption of innocence, the right to liberty, and the freedom of mobility. Side Negative also argues that she is a flight risk, to which my previous speaker already debunked by showing you all of her personal circumstances.
2 minutes for the cross-examination.
Good evening, Mr. Speaker.
Good evening.
Does a conviction import with it evidence of guilt? Does the conviction import with it
can still be
evidence of
appealed,
guilt?
and it can still
yes,
be
but there's
overturned.
evidence. Are you aware of the case of People versus Nitschka?
No.
Are you aware?
Enlighten me.
So I'm so sorry. In this case, bail was denied because for reason of conviction it imports evidence of guilt, which means it is no longer a matter of right because presumption of innocence is no longer present.
Yes, we
because
do
he was
agree that it's a
already
matter of
convicted.
discretion.
Okay. Are you aware?
We never said that it's a matter of right.
In your arguments, you're saying that Delarama, Purganan, and Enrile are applicable in this case, right?
Yes.
In these cases,
Pursuant to Article 8 of the New Civil Code,
Mr.
stare
Speaker,
decisis.
respect my time. In these cases, are the accused charged or convicted? In the case of Delarama, Purganan, and Enrile, are the accused charged or convicted?
Which one of them? In Enrile versus
all three
Sandigan
cases.
Bayan, it was before
In Purganan, Your
conviction.
Excellencies,
But Your Honors, in
Purganan, and
Delarama,
Enrile,
it said that
there was no
regardless of the
conviction
stage of
yet,
the proceeding,
which means they are still entitled to presumption of innocence.
Yes,
in this case,
that's true.
conviction is already here, which means Imelda is no longer
Your Honor,
presumed to be
Delarama
innocent,
ruled that
although
regardless of the
entitled to
stage
appeal.
of the proceeding,
Okay.
regardless of the merits of the case, it can still be applied.
So, are you aware of the ailments Imelda claims she's suffering?
Yes,
in
she
the
has
motion for leave.
static
According to her submission,
mini-strokes,
right?
diabetes, and
right?
multiple organ failures.
Are you
all
aware?
of which
Are you aware,
are
Mr. Excellency? Are you aware of the outpatient procedure?
I'm sorry,
Are
what?
you aware of outpatient procedure? Are you aware that
what's your point,
these kinds of illnesses are under outpatient procedure, which does not require hospital admission?
We are against hospital arrests,
Are you
house
aware of the
arrests,
case
and
of
any
GMA,
form of preventive
GMA and
detention.
Erap Estrada?
Is there any reason to
In the
detain
case
her?
of GMA and Erap Estrada, were their rights to be taken care
If
of
she
for
is
their
not a
illnesses
flight risk,
denied?
would you allow her
In the
bail?
case of GMA.
Okay, Vic, you've got 4 minutes to tell us why it would not be practicable to allow Mrs. Imelda Marcos to post bail even on humanitarian grounds.
A statute derives its validity from the purpose for which it is approved. To construe it in a manner that disregards or defeats such purpose is to nullify or destroy the law. This is the enunciation of the Supreme Court as it denies Panfilo Lacson's application for bail in People versus Lacson. The law is clear. Imelda is no longer entitled to bail as she lost it procedurally as a post-conviction remedy, and second, substantively, because it's no longer a matter of right. They weren't able to defend that. They weren't able to engage that in this debate. The primary burden of side affirmative is to convince us that Imelda is under unique conditions and circumstances as to warrant a relaxed application of the law upon her, that having her detained will be so detrimental to her fragile health and her aging condition. They failed to do that also in this debate. On practicality, 2 points. Humanitarian consideration can be still provided to Imelda without granting her provisional liberty, and second, to do so would strike imbalance between the accused's right and the compelling state interest embedded in this case. On the first argument, Imelda claims that she is under fragile health condition brought about by at least 7 illnesses, to which she claims she has diabetes, hypertension, cardiovascular disease, static mini strokes or hearing losses, we're not clear about that, chronic, recurrent UTI, respiratory tract infection, and gastritis. Ladies and gentlemen, this may sound like highfalutin medical terms, but a cursory research will tell you that these are ordinary illnesses experienced by an aging person. According to the Philippine Journal of Internal Medicine, and as echoed by international clinical practice of the WHO, these ailments simply require outpatient treatment, which means she's not necessarily needed to be admitted to a hospital. And even if it's necessary, even if it becomes necessary to be admitted in a hospital, it can still be provided through special detention centers like house arrest, hospital arrest, which means that her needs can still be taken care of at the end of the day without necessarily setting her free. In fact, this has been done before in the case of GMA and Estrada. Therefore, it is impractical to relax the application of the law for reason of equity when equity can still be provided in the normal application of the law. This is a pragmatic factor that the court must consider in exercising its discretionary power to grant bail. In Yap versus Court of Appeals, as cited in Leviste, the court held that the discretion to extend bail during the course of appeal should be exercised with grave caution and for strong reasons. Side affirmative failed to do this in this debate. Going to my second argument, there is a compelling state interest that must be upheld in this case. As held in Leviste versus CA, it is very well explained that society has a compelling interest in protecting itself by swiftly incarcerating an individual found guilty, conviction, Your Honor, beyond reasonable doubt of a crime serious enough to warrant detention, to protect the protection of community and to not further delay its punishment. We did not argue that Imelda is a flight risk. What we argue is she's no longer entitled to bail because she's no longer presumed to be innocent. This is a discretion. In their side, they're able to at least take care of Imelda's needs, but it denies justice, it extends injustice, and actually extends impartiality of the court. In our side, in Arellano's paradigm, we never deny Imelda of humanitarian or humane treatment, but rather we're able to uphold the compelling interest to punish a crime, ladies and gentlemen, which they have failed to balance in their model. In this case, Arellano law is proud to oppose.
2 minutes for the cross-examination.
Counsel, is hospital arrest a form of preventive
Yes,
detention?
it's a detention.
Yes or no?
Because there is already
Counsel,
conviction.
the purpose of preventive detention is to secure
There's
the
not
accused's
even
appearance,
preventive
correct? Is it
there's not
correct
even
or not?
preventive detention
What is
when
the
there is
purpose
conviction.
of preventive
It's actually
detention?
just serving the sentence.
It's to secure the accused's appearance in court, correct?
Yes, we can
And
still
this is
secure
also
that.
the purpose of bail, correct?
Yes.
In the absence of any bail-denying circumstances, would you grant
That's
Ms.
not
Marcos
the case in
bail?
Leviste versus CA, which
Answer
you
me.
also raised
Counsel,
in this debate.
you're not being responsive.
Okay.
In the absence of bail-denying circumstances, would you grant Ms.
Yes,
Marcos
but
bail?
only if
That
it is
is
a matter
concession,
of
Your
right.
Honor.
Only if it is
no-
a matter of
Okay.
right.
You
But if
already
it's a matter
conceded,
of
right?
discretion,
In the
and
absence
when
of
they have
bail-denying
already
circumstances,
forfeited
you would
the
grant
right
Ms.
to
Marcos.
avail for bail because of impunity
Counsel,
and not
have you read the
appearing
case of
in
Alonte
the
versus
promulgation
Arellano?
of judgment, you already lose this kind of
Counsel,
right.
Have you read the case of Alonte versus
Enlighten us.
Arellano? Due process is an enshrined
Due
right that
process is
cannot
still
be
provided
denied
to her.
even to
Hearing
the
was
most
still given.
undeserving.
What are you talking about,
Is
Mr.
the right
Speaker?
to bail...
Due process was never
This
denied
is
to
a debate,
Imelda.
not a shouting match.
Due
Is the right to
process was
bail
never
part of
denied to
due
Imelda.
process? Is the right to bail part of due process?
Yes.
In Paderanga versus Court
So when
of
you
Appeals,
deny bail, you're
the right
saying
to
that
bail
due process
flows
is
from the
also denied?
presumption of innocence, correct? The right to bail flows from the presumption of innocence. And the presumption of innocence...
The conviction has already
Counsel,
been made.
in
There is
Enrile versus Sandigan
There is
Bayan.
no presumption
Counsel,
of innocence because Imelda has
please be
already been
responsive.
convicted. Okay, go.
In Enrile, humanitarian considerations was factored into the court's discretion. Yes or
Which
no?
was not even raised by
Yes
Enrile
or
in
no?
the first place.
Yes
Only
or
when
no?
the court only when the court tried
He's
to,
not being
tried to decide
responsive.
on their own.
The refusal
I'm
to
responding
factor
you,
it
you're
in
just
is a
not
denial
liking
of
my
due
response.
process. Counsel, the purpose of bail necessitates a balancing act between the accused's
We already
right and
balanced that
public
in our
security.
paradigm.
Yes?
We are trying to say that there's a need for the punishment and you
In
need to also
Proreo,
detain
in the
Imelda
Proreo
when not
doctrine, it must be in favor of the accused.
Let's now hear what our judges have to say about our debaters. Attorney Shao, how did the affirmative side do?
Yes, I think you presented a very persuasive case for your side. However, I would have wanted to hear more of why those ailments or sicknesses really require humanitarian treatment. No? So that's something that would have been more helpful, perhaps. But in any case, you did a good job, and congratulations.
And Attorney Cruz, how did the negative side do?
Well, first of all, congratulations to both teams. I can feel the passion of both teams. But for the negative side, I sense that your passion is genuine, that you really want Mrs. Marcos not to be free. I have comments for each, but I'll try to just generalize. So that's the first thing that I noticed, the passion is genuine. Second, I think all three had too much reading. It's better just to have some notes and to give and improvise. And you should allow the other party to answer in interpolation. And finally, I think you have to focus on the issues, like the other party said. Thanks.
And now let's hear from our chief adjudicator, Judge Sapadan. Your Honor, who did the judges pick for Best Speaker?
For Best Speaker, it was a clear choice. Congratulations to Ms. Alexine Bangcola of the Arellano University School of Law.
And the school that won tonight's round.
Arguments raised in tonight's debate were very logical, passionate. But the better team in tonight's debate is also from Arellano University. Congratulations.
A big congratulations to Arellano University for winning the first semifinal round. I'm Mike Yoreta. Thank you for watching.